us and then declare this meeting open. Then we proceed from there. Please, over to you, Mrs. Ankama.
Good afternoon, everyone. Good afternoon, good evening, good morning, depending on your time zone. You're welcome to another webinar organized by Shati. I want to use this opportunity to thank you for believing and trusting in Shati. And I also want to thank you for sparing your time despite your tight schedules to join this webinar. We're going to learn more about arbitration today. All our discussions have been on mediation, but now we're extending our tentacles to see how we will look at arbitration and apply it in our own institute and in everybody's life, especially those that are chronic ADR practitioners. I want to welcome our resource person. Thank you very much, sir. Mr. Asari, all the way from Ghana. Thank you for honoring our invitation. At this moment, I would like to declare this meeting open. I would like to say, stay focused, have an open mind, ask questions, and collaborate. Thank you very much, and God bless you all.
Thank you, ma'am.
Amen. Thank you, ma'am.
Thank you. Thank you very much.
Thank you, ma'am.
Thank you. Thank you very much, Mrs. Ankama, for the welcoming speech. Here with me, I have Gloria Raju. She's one of my assistants, and then so instead of muting everyone, please, if you are not speaking, we'll appreciate if you keep your microphone muted. Thank you very much. Thank you, Ms. Roskana, for that wonderful introduction. Gloria Jude, she's my assistant. Thank you for joining in. We are going to be coordinating the meeting together. So if you have questions, you have anything, you can drop it on the chat. She will pick it, and then if there is need for anything, she will draw our attention as well. Let me appreciate the presence of Mr. Samuel Osar NN. He's one of our faculty members and one of our distinguished ADR practitioners. You know, in fact, his presence and his work is making Shati go both nationally and internationally. Shaihum, you are welcome. Thank you for joining all the way. Is it from India? They are about, so happy to have you here. I want to appreciate our speaker as well. So without wasting time, let us go straight to our activity for today. Let me have the privilege of just handing over to Mr. Isaac Asare. I will give him the opportunity of introducing himself. He is one of the leading ADR practitioner in Ghana. He is the founder of the Africa Center for Collaborative Dispute Resolution. And for lack of proper description, I think it's better to address him as an ADR practitioner because he is both a mediator, an arbitrator, a negotiator. He is a trainer, a facilitator, you know, in all the spheres of ADR practice. So let me give him the opportunity of telling us a little about him and go into the activities for the day. Please, I will encourage you to take note, write down your questions. If you have contribution, I believe that you have opportunity to do so in the course of the meeting. Thank you very much. Let me go back to Isaac. I can see Miriam too. You're welcome. Thank you very much. Thanks. I can't mention everyone by name, but we are happy to have you here. Thank you very much. Mr. Isaac, over to you. Yeah,
Okay, thank you so much.
Okay.
Good afternoon, everyone, and good morning to the other people who are from the other side, who may be having morning when you go to maybe Asia and other places. Good morning and good afternoon. It's evening. It's 3:20 here, so we are inching closer to the evening. So good evening to Nigerians also. And thank you, Nanchan, and your executive director, and all the people at Settlement House for giving me this opportunity to share the little that I have on arbitration. I'm happy to do this as the first person to speak on the arbitration series, and I don't take the honor kindly. So thank you so much for this opportunity, and to meet all distinguished people to have a discussion with them. So I asked him to, he has already introduced me already, and he said that should we do another introduction. I don't think I have any other useful information to add. All that I will say is that I'm an ADR enthusiast, so I like anything about ADR, and I want to see more ADR practice happening in the African continent, particularly in Ghana, in us, West Africa, and other part of the country, because we seem to talk more on what is happening around the world, what is happening within maybe London, US, and Europe. But when you ask somebody about even what is happening in Nigeria, somebody from Ghana may not even know that maybe Nigeria even passed the new Arbitration and Mediation Act in 2023. But they will know that there is a Singapore Convention which was passed. So these are some of the things that I want to see in Africa, and I hope that we all work together in achieving that goal. We collaborate. That is why the center that I had in Ghana, which is the African Center for Collaborative Dispute Resolution, we are looking forward to collaborate with all institutions within the country, within Africa, and also to extend our boundary and tentacle so that we all can achieve a better ADR practice together. And that is what we are looking forward to. And I'm happy to be here. So if I have the opportunity to go ahead, then I'll share my screen with you. Then the presentation will start. Please, you can put your comment or your chat in the comment section. And if I see them, I'll answer them. If I don't see that the moderators are also here, they also prompt me so that I can answer as to the best of my knowledge. I don't know everything about arbitration. I'm still studying more, and there are people here who may even know better than what I know. So I'm going to share what I have with you, and I also expect to learn from you as well. So thank you, Nanchan, for the invitation, and thank you to all the officers and the people at Settlement House. So Nanchan, if there's something, you can bring it up. If there's nothing, then I can proceed. Please. Okay, is there any other thing or I should continue? Hello, Nanchan, can you hear me? Am I audible?
Yes, go ahead, please.
Okay, thank you. All right, so today I was invited to talk about the Shati, which is Settlement House arbitration series, which is a webinar going to be facilitated by me. My name is Isaac Asari, as they have already introduced me. I'm the founder and president of African Center for Collaborative Dispute Resolution. Our main office is based in Ghana, but we hope to enter other African countries. So we are going to look at an overview of arbitration process, what you need to know. So this is a big question for all of us to ponder over it when we say over an overview of arbitration. It means that everything involved in the process. So the question is more on the process, the arbitration process itself. But I'm going to talk more about what arbitration is, what arbitration means and the history behind arbitration practice before I zoom into the process of arbitration, or maybe they have heard about arbitration, but they do not understand what arbitration is. Then I'll take time to do that. Right. So I pose this question: what is an arbitration? For those of you who understand arbitration, if somebody can help us with it, what is an arbitration? So from the audience, I would like to hear from you. Anyone, you can raise your hand using the hand raising option, then you can be called to answer the question. And the moderators too can also assist in doing that. Who can tell us what an arbitration is? Because today we said we are looking at an arbitration overview of an arbitration process, but we must understand what arbitration is. What are we looking at its process? So that's why I pose this question. What is an arbitration? So if somebody can help us with it. Okay, anyone? Or none of us has heard about arbitration before. We don't know what arbitration is. Okay, Nanchan, you want to say something?
Well, arbitration is one of the mechanisms of ADR, whereby a third party neutral is appointed by the parties to assist them in deciding their problem, their issues, their disputes. And in this case, the third party is called an arbitrator, and that arbitrator makes a binding decision called an award, which is ordinarily not appealable, but one can apply to set it aside based on certain conditions.
That is great, awesome. So it means that in simple terms, what normally I tell people that I meet is that when we talk about arbitration, as Nanchan has said, but what will make you to remember arbitration most is that look at arbitration as a private court, as simple as ABCD. Look at arbitration as a private court. So we have the normal formal court system, and we have a private court whereby the parties themselves are set up a court to hear their matter. And that is what we call arbitration. So it is not the court that has appointed a judge, like the court system whereby a judge is appointed by the Chief Justice for the person to hear the case. When it comes to arbitration, it's different, whereby the judge that we call arbitrator is appointed by the parties. So the parties appoint the judge, and they also agree on their own rules and regulations governing the process so that they can achieve the results that they are looking at. So this is what I put here as definition of arbitration, as arbitration is a consensual process for the resolution of dispute, but an impartial tribunal appointed by an agreed method of the disputing parties. So an arbitration is what the first thing that you have to deduce from the definition is that it's a consensual process. It's two disputing parties or two parties, two or more parties that have come together to select a process, which is called an arbitration. And now they have appointed their own adjudicating body called the tribunal. So the tribunal can be just one, a sole arbitrator, or it can be an odd number. When we say an odd number or an even number, we are talking about 1, 3, 5, 7, and so on. So that when there's a decision making, they can have a decision that will be we don't have anything in arbitration which is win-win. We are looking at win-lose. So when we have two people and each of them is giving different or divergent views, it will be difficult for you to have an outcome. So that is why they normally pick an odd number or even a sole arbitrator. So definitely a sole arbitrator will go one way or the other. So it's a method that the parties select their own tribunal by an agreed method that the parties put in place for themselves, which is used by them. Then the question is, if the parties are putting methods to or putting mechanisms in place or putting their own structures in place to resolve their own disputes, then why are they choosing that? Which if that is arbitration, why are they doing that? One, will say that then it has some kind of benefit. That is the reason why the people have now decided to choose their own process and helping them to resolve their own issue without relying solely on what may happen at the court or what the normal traditional litigation system will offer them. So that is why we are saying, why arbitration? So why will people go for arbitration when there is court? Why will somebody go for arbitration? So somebody will go for arbitration because they want a situation whereby they themselves can manage their process. They themselves can decide how their process should go. They themselves should have some kind of privacy whereby people will not intrude. Court is a public place, but in arbitration, the parties themselves select where they want to meet, how they want to meet, and who is accepted to come and listen to whatever that is happening. So arbitration becomes private. That is why we say, well, everything that happens within the arbitration is what? Confidential. Confidentiality is assured when people meet and discuss their own matters. So all these things is the reason why people will choose arbitration over the normal litigation process. And so that they sometimes businesses also like to protect their trade secrets. For instance, maybe there are big giants in maybe the telcos industry are having disputes, or they are having a dispute with a partner within the same organization. If they send that matter to the courts, it is likely that somebody may voice out or say something within the court proceedings or anything which is accessible to the people, the public, and somebody can go and look at it and see some trade marks that it pertains to only their work, or trade secrets that the people only know and be using, which somebody can go and use it, and they can have a rival in the field that they are operating. So people would like to have a private way to resolve their own issues, whereby to give them a result that they are happy with, a result in a timely manner, the result that they can manage the process to suit the period that they can wait for such results. And that is why when you come to arbitration, we have forms, various forms, whereby people will just stipulate that we want this matter to be expedited within 2 months, 1 month, or 3 months. We are done with the arbitration proceedings so that they can have, or things must go on and work perfectly for those organizations. And that is why people choose arbitration. So having known arbitration as a method that the parties themselves set up to manage their dispute for them, then what is the history behind arbitration? Why did arbitration came into existence? Has it been practiced before, or just how did it came into practice? Then, if you look at, for my reading, you will see that a number of authors have argued that the first arbitrator, that is King Solomon, those who are Christians, and let me also, when I started, I didn't take this opportunity to also say happy Eid to our Muslim brothers and sisters. So let me use this opportunity to say it. And for those who are familiar with the good books, which is the Bible, you see that King Solomon, the authors have argued that King Solomon was the first arbitrator and had used a procedure similar to the modern day procedure whilst resolving a dispute that emerged when two men protested that they were the mother of a baby boy. So this story, particularly if you are a Christian, sometimes if you are not even a Christian, this is a popular story. Everybody know most of people know in the Bible that two men were arguing about a baby. One unfortunately slept on her own and died, and the other and took the other person's own, and it became an issue. And King Solomon used arbitration. That is what the scholars are saying, that this method that King Solomon used they might not have called it arbitration then, but they think that it's an arbitration process, which modern day we call it an arbitration. And if you look at even the African culture, for instance, if you come to Ghana, for instance, we have a system called customary arbitration, which is used by the chiefs and our elders within the community. So this is something that was there even before the colonial masters came into Africa. So another influential figure, that is Philip II, had used arbitration to amicably resolve a territorial dispute that took place way back in the 337 BC. They said that the Philip II used arbitration and resolving some of their territorial disputes that they have with challenge, because there were a lot of people moving across the continent, moving across Africa and other places, looking for areas and all that. And if you look at even when they had the Berlin Conference, whereby they divided Africa into pieces and shared it among themselves, all this, and they used some mechanism that we say that some arbitration happened around that side. Then scholars have also said that in Roman law, we call something compromisum was used to indicate a process of dispute solution which would draw out a compromise between the parties. So this word, which simply means compromise, means that they used to use this word in some way. But if you look at this word critically, it is more geared toward mediation. But scholars are saying in adjudicating on their matter, sometimes they feel that people should be able to compromise on certain issues. So which is called, maybe they had, which in modern days we may call it MEDAP or ADMED, which is called a hybrid process within the arbitration process, whereby maybe they started with arbitration, but within the arbitration, they did mediation in the arbitration and they were able to come out with a compromise solution, which becomes a consent award. Then, therefore, we can see that there have been a number of examples of arbitration that actually took place in ancient era and can be seen as a trailblazer for the laws we have today. So, learning from us, that is the reason why we've been able to now have the laws that we have, and internationally and locally, the laws we have.
Can you hear me?
Is somebody trying to ask a question?
Please go ahead.
Okay, thank you. All right, so let's look at the original formation of we are still looking at the history, the original formation of the League of Nations around the 1919, where one of the momentous events in 1919 was the formation of the League of Nations following the Paris Peace Agreement in 1919. The League of Nations set for itself some lofty ideals, relevant among which, for our purpose, was the commitment to improving global welfare through international commerce. So after the League of Nations was set up in 1919, it was agreed among nations, the League of Nations, that they are going to trade among themselves. So that is where they started the international commerce. So at the time, it was discovered that one of the basic requirements for the expansion of international commerce was dispute solution mechanism. That will be internationally or international commercial minded. So once we are going to trade among ourselves, what dispute solution mechanism do we use so that it will be able to benefit or have international commercial minded, so that the merchant will not suffer? Because when somebody from US or from Europe is trading with somebody in Nigeria, the question is, whose law should we use? Should we use the Nigerian law or should we use the European law? But they needed something which will have commercial minded, a dispute solution mechanism that can help them to do that. So international arbitration was identified as the preferred mode of settling international disputes. So they introduced what we call international arbitration, so that they can use it to trade among themselves and use it to resolve cross-border disputes, so that they can have simplified or modified rules which will be used to resolve their disputes when they have cross-border disputes among nations. However, a thorough examination of the mechanism of international arbitration revealed that these mechanisms suffered a number of major defects. Chief among them were the fact that most states did not recognize a valid arbitration agreement that's related to a dispute that might arise in the future. They only recognize those which related to a present dispute. So at first, people didn't really, or state didn't really understand those processes. So they were only recognizing disputes, the current dispute. They didn't look at the future dispute, whereby they make an agreement in a contract, and if a dispute occur in the future, they use it to organize. They were more looking at the immediate, what is happening, or presently what is happening currently. Then even in these states where agreement to submit future dispute to arbitration were recognized, there were no effective mechanism for the enforcement of such agreement. So even states that have or that recognize this agreement, there were no mechanism to even enforce such agreement like we have today. So court routinely took jurisdiction over such disputes. So the courts, jurisdictional court, like if you're having an Okay, sorry, I think I was muted. Okay, let's move on. Courts in those jurisdictions, like Nigeria or courts in Ghana, will just take over because it's their dispute, whereby the dispute may have an international nature. So the court took decision over such dispute and refused to refer the parties to arbitration. The only remedy was sue for damages for breach of the arbitration agreement, which proved to be very effective remedy. And people had suffered a lot of difficulties in enforcing their agreement, their arbitration agreement. This difficulty involved in enforcing foreign arbitration award and was also identified. So when you also had foreign arbitral award like Ghana, Nigeria, if you are a Nigerian company and you have a Ghanaian company and you have an award between them, where do we enforce it? Can you go to Nigeria and enforce it if the country repatriate back to Nigeria? Is that one possible? So once people were not recognizing that, states were not recognizing that, it was difficult for people to do that. So around 1922, 1923, to deal with this first two of the problems identified, the League of Nations adopted the 1922 Geneva Protocol on arbitration clauses. The most effective provision in the protocol was found in clause 1 of the protocol, which provided us each of the contracting states was to recognize an agreement whether it relates to existing or future differences between parties, subject respectively to the jurisdiction of the different contracting states by which the parties to a contract agree to submit to arbitration, or any difference that may arise in the connection with such a contract relating to commercial matters or any other matter capable of settlement by arbitration, whether or not arbitration is to take place in a country to whose jurisdiction any of these parties is subject to. So this was a Geneva Protocol that was adopted by the League of Nations so that it will be used to curtail the challenges that the people were having, so that states can now start recognizing arbitral agreement. So the protocol also provided for the procedure of arbitration, including the fact that the composition of a panel was to be in accordance with the will of the parties or the laws of the territory where it was made. So you see parties' autonomy was also taken care of here. In the meantime, state felt the need for an arbitration organization that would be truly international. The International Chamber of Commerce took up this challenge in 1922, adopted its first rule on arbitration, and in 1923 established the International Court of Arbitration. So if you look at the ICC, which is the International Chamber of Commerce, they have done a lot of work when it comes to dispute resolution across the continent, both in Africa and across the world. So they because of commerce, because they are trading, they set up this arbitration institution, and later now they have added mediation to it as well. The ICC that set off on its way to become the leading international arbitration institution it is today. So this is where it started from. So when you see maybe ICC have grown, their institution have grown to this level, they started from somewhere. The same way that institutions that are starting now will later you also be said that they also started from here. Now they have grown, and I hope Shati also get to that level one day. So in 1927, the issue of the recognized enforcement of foreign award arbitration was left unresolved for another 4 years until 1927, when the League of Nations adopted the Geneva Convention for execution of foreign arbitral awards. So now they have solved the problem of where we can resolve the matter in 1923, and the institutions have come up. But what was left was, how do you enforce a foreign award? So in 1927, the League of Nations adopted the execution of foreign arbitral awards. By its provision, contracting states agreed to enforce arbitral award made in conformity with the 1923 protocol in the territory of another contracting states. The convention was adopted by a lot of countries and was greatly successful. Then, in 1938, the diversity in national arbitration laws providing for the composition of arbitration, the tribunal, the power of the arbitrators, and the process generally made the practice of international arbitration cumbersome and uncertain. There was an attempt to deal with this problem by the International Law Association when it adopted the Amsterdam Rule in 1938. The rule contained the provision concerning the constitution of arbitral tribunal, the power of arbitrators, the rights of evidence, the hearing, the content of an award, the fixing of costs, and the several other matters important to the arbitration practice. While historically important as an early attempt at harmonization of the arbitration practice, the rule had no practice effect because World War II broke out in 1939. So if you look at, they were making a headway, and now World War II has come into being. Then, after the Second World War, the now United Nations has been formed. League of Nations is no more. Now it has become United Nations. They still needed to do something which will help in international trade. So the Second World War ended in the middle of 1945, and the United Nations was formed in October 1945, ostensibly as a successor of the failed League of Nations. The UN took up the task of development of international arbitration from where the League of Nations has left off. In consultation with the ICC, which had become the leading international arbitration institution, the legal framework of international arbitration was examined with a view to making it more efficient, effective, and therefore attractive as means of resolving international commercial disputes. So the examination brought to the fore one of the weaknesses in the 1927 convention, the requirement of a double executor. This was the requirement that the party seeking the enforcement of the arbitration award had to prove the condition for recognition have been fulfilled. The only way to do this was to have the award recognized in the country where it was made, before further proving it in the country where recognition enforcement was sought. This was an expensive and cumbersome process. The ICC therefore undertook a revision of both the 1922 protocol and 1927 protocol and decided to combine the two into one instrument. So the result of the move undertaken by the ICC to merge the 1923 protocol and 1927 convention is the New York Convention on the Recognition and the Enforcement of Foreign Arbitral Awards of 1958. The lucidly written instrument radically changed the legal framework for international arbitration practice and may rightly be considered as the ground norm of international arbitration practice. As you have seen, a lot of people are quoting the New York Convention as the basis for a lot of enforcement because a lot of countries have signed under them and it is recognized worldwide, and people have even done their acts to go under it. First, it provided for the presumption of presumptive recognition and enforcement of arbitration agreement by specific performance. The contracting state undertook an obligation under the international law to deny parties access to their state court for parties bound by arbitration agreement unless same was null and void, inoperative, nor incapable of being performed. Then, secondly, it provided for the easier means of recognition and enforcement of foreign and non-domestic arbitral award by making them presumptively enforceable and shifting the burden of proving that they ought not to be enforced on very limited grounds set out in the convention of the party resisting the recognition and enforcement. The short test of the New York Convention meant, however, that the nation states were to provide for the regulation of the arbitral processes by the national arbitration legislation. The diversity in national arbitration legislation led to the diversity in arbitration procedures and practice. It was realized that we brutally international and there was the need for harmonization of national laws. So if you look at the New York Convention, people have adopted it. But if you look at country by country, you will see that countries have adopted their similar arbitration rules and regulations which govern their domestic arbitration, but which is also in line with the arbitration, the New York Convention. Then the 1970, the UNCITRAL also came into force. So the task of the harmonizing arbitral laws and practice was assigned to the United Nations Commission on International Trade Law, as we call it for short, UNCITRAL. The UNCITRAL has been established earlier with the aim of creating an economically interdependent world. UNCITRAL was to provide an improved legal framework for the facilitation of the trade and investment. To carry out this assignment, UNCITRAL undertook the task of achieving a progressive harmonization and modernization of laws of international arbitration practice. So UNCITRAL first came up with the UNCITRAL arbitration rules in arbitration in 1976, providing a standard means of conducting an arbitration process for parties who adopt ad hoc arbitration. That is, arbitration not conducted under the rule of an institution. So when we talk about ad hoc, so the UNCITRAL, if you look at a lot of countries, Ghana is an example. If you look at Ghana law and look at the UNCITRAL rules or the UNCITRAL rules, it's similar to even the laws that Ghana is having, because the rules allows the flexibility, and a lot of countries were comfortable with those work that was done by UNCITRAL. So some of them just made few additions and adopted them. So to further provide for the harmonization of the laws on the UNCITRAL came up with the UNCITRAL model law on arbitration in 1985. The idea was to provide a model law on arbitration which contained pro-arbitration provision and incorporated all essential doctrines of arbitration, which could be copied and pasted with a modification by state looking to pass modern arbitration legislation. In the words of the preamble of itself, this is what is stated. The model law is designed to assist states in reforming, modernizing their laws on arbitration so as to take into account the particular and futures needs of international commercial arbitration. So states learned from what UNCITRAL was doing and came up with a lot of their acts. So it covered the stages of arbitration process from the arbitration agreement. So we'll come to the process. So some of the process that you are looking when we are talking about arbitration, overview of an arbitration process. So the UNCITRAL rule covered the stages of arbitration or arbitral process from the arbitration agreement. Because in arbitration, there must be an agreement which will give effect to the arbitration. The composition and the jurisdiction of the arbitral tribunal. So then when we talk about the composition, we are talking about the number of the tribunal, how many, who is supposed to do what, and who is supposed to, what selection, the selection process. Then the jurisdiction. When we're talking about jurisdiction, we are not talking about the court jurisdiction, like maybe this court in Kaduna. So the court does not have jurisdiction in maybe Lagos State. That is not the kind of jurisdiction that we are talking about. Jurisdiction is mostly on the scope, what the parties have given to the arbitrators, that the agreement will specify that the arbitrators have power or the tribunal have power to deal with A, B, C, D matters of maybe the contract or the dispute. That is the jurisdiction of the arbitral tribunal, and the extent of the court intervention through to the recognition and enforcement of the arbitral award. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and different legal or economic system of the world. The model law has been widely adopted by states, and most arbitral legislation passed after 1985 are crafted on the arbitral model law, and it has been so successful that in the arbitral practice, countries are designated either as a model law or non-model law jurisdiction. Then from 1985, after the model law to date, what has been happening in the system? So the period 1985 to date has seen the phenomenal growth in the adoption of international arbitration as a means of resolving disputes, the doctrine of parties' autonomy. So when we talk about parties' autonomy, people looking at parties having the authority to decide where their matter to be resolved, even to make a prior agreement in their contract. When they are doing a contract today, they can make a prior agreement. When they have to select arbitrators or the tribunal, the parties have the right to design the way the manner the people must be selected, or the rules that must govern the process. So it gives the parties more room to function in the process. Then arbitrability, what matters can be arbitrated. It is every matter that you can send for arbitration or send for international arbitration. Then we look at separability of arbitration agreement. So when we talk about separability, we are talking simply about the arbitration agreement, whether it is in the contract or it is in a separate agreement, or it was even a text message or an email. We are saying that it is separate from the actual contract itself. If the contract fails, that agreement will be used to settle the matters relating to that contract. So that is why we're saying that it is separate from the contract, not to say that it is not part of the contract, although it is part of the contract, but that is the mechanism or dispute resolution mechanism that will be used to settle any matter that is arising from whether the contract can be executable or not, or can be performed or not. Then that is why we call it is separate. You make it separate from. So most laws recognize that and have separated that from the contract on its own. Then we have competence. Competence principle is more about the arbitral tribunal. When parties have designed their own interventions, they are telling us that yes, we have appointed these people, and we know that the people have capacity. So it is the tribunal to be able to rule on their own jurisdiction, to say that, oh, we have jurisdiction over this matter, or this matter that you have submitted to us, we do not have jurisdiction over this matter. So, and that is what we call a competence. So all these things have crystallized and are routinely stated as the obvious. The disability of limiting state court intervention in arbitration proceedings has also become increasingly recognized, because the courts in some jurisdiction will even tell you that once a matter is pending before arbitration tribunal, you cannot take another action in court, and you must allow the arbitration process to be completed before you can do that. Then, in the past few years, there has been extensive development in the area of extending arbitration agreement to bind non-signatory parties to arbitration. There has also been significant development in the enforcement of international arbitration award, which has then we are talking about arbitration rules. When we mentioned the arbitral rules and other things, then in the same way, we have centers that practice ADR or institutions that practice the arbitration. They have their own rules that they use in managing the process, if the parties so wish to adopt that. When we mention parties autonomy, we said that parties have rights to choose how they want the process to go. So they can decide to accept your rules, or they can decide not to accept your rule. But most international arbitration institutions provide rules which govern the resolution of the dispute to be resolved via arbitration. The best known rules of the arbitration include those of to mention a few. Some of them are many. We have the American Arbitration Center. We have the American Arbitration Association rule. We have the International Chamber of Commerce rule. We have the London Court of Arbitration rule. We have the Singapore International Arbitration Center rule. We have the Hong Kong Arbitration Center rule. Then we have the investment arbitrators Investment arbitrators are also often resolved under the rules of the World Bank's International Center for Settlement of Investment Dispute, which is called ICID, or the United Nations Commission on International Trade Law, which is the UNCITRAL rules. So depending on what people want. And there are other rules. So many arbitrators involving Russia businesses also take place under the rules of the Stockholm Chamber of Commerce, which is the SEC rules. And parties can also design their own rules, which can be used to resolve such matters. So these are some of the popular international ADR centers that you can use their rule. Then, how are arbitration rules enforced? So thanks to the treaty known as the New York Convention, which entered into force on 7 June 1959, arbitration award can be enforced in most countries, unlike traditional court judgment. Why do we say this? Because when you make a judgment in Nigeria, you cannot enforce same judgment in Ghana because the Nigerian court does not have jurisdiction over Ghanaian or the Ghanaian court, or does not have jurisdiction here. So, but when you make arbitration agreement, Ghana have signed the New York Convention. So if there's a dispute between a Ghanaian company or Ghanaian individual and a Nigerian, and they go under arbitration and resolve the matter through arbitration, that agreement can be resolving, can be enforced in Ghana against the Ghanaian counterpart or Nigeria against the Nigerian counterparts. Why? Because both countries have signed the New York Convention and they can go under them because they have a reciprocal agreement under the convention to enforce it. So when you look at the New York Convention, over 150 countries have ratified the New York Convention today, meaning that arbitration award can be enforced in approximately 3 out of 4 of the countries recognized by the United Nations. So if you have 3 out of 4 countries that when you do an award, you can enforce it, then it's a good news for you. Then and for businesses to also use. The primary law on the basis of which international arbitration lawyers argue a case are the governing laws of the contract or the law of the tort relating to the contract and the arbitration law of the seat of the arbitration and the New York and the Washington Convention. So in most cases, when you choose the seat of arbitration, normally the arbitration agreement may specify that the governing law may be the governing law of the contract or the governing law of the tort of the contract or the seat, the laws that govern the seat of the arbitration. But in most cases, if you are choosing a seat as a business person or as an arbitrator or as a lawyer or anybody helping people to go to arbitration, you must look at the state law and the state intervention when it comes to arbitration so that you don't choose a law or you don't choose a state which the state or their state laws allows for the state to interfere in the arbitration process, which will destroy the process because once maybe somebody may not be willing to go to the process, they will be using the court to frustrate the process. So in choosing that, you must critically look at the seat because normally the seats of the arbitration, the prevailing law within that country governing arbitration will be the law that will pertain. Then let's talk. In summary, to all that we have been discussing, to account for the origin of commercial arbitration, the subject can be conveniently discussed under 2 heads: the method used by the grains and the merchants in the dispatch of their affairs. So those who used to do the merchants in the past, in the areas whereby civilization has not even taken place, when they were trading among nations against nations, even Ghana was not Ghana at that time. Sometimes, so some certain countries were not even existing as at that time. What they were using. Then the examination of the cases in the law of contract that contain arbitration agreement and the reaction of the courts to them. So what has been the court's action when it comes to arbitration agreement and those things. Now we come to the main issue that brought us here today, which is the arbitration process, what you need to know. So general principle when it comes to arbitration process, the general principle is that there must be an agreement to arbitrate. general principle in arbitration. If you don't have any agreement, how do you go for an arbitration? So parties involved in arbitration or parties involved must agree to submit their dispute to arbitration. This agreement is often included in contract or can be formed through a separate agreement. So it can be included in the contract, as I mentioned earlier, or it can be a separate document which makes reference to the contract that this when anything happens within that contract, this agreement will be used to settle that matter. Arbitration agreement typically outline the scope of the dispute subject to arbitration, the selection of arbitrators, the rules governing the arbitration, and the selection process and all that. So when it comes to the types of agreement, there are two main types. The first one is prior agreements. The agreement which has been incorporated in the contract or a separate agreement which is in line with the contract. That is one. That is the prior agreement. That is the where before even anything happened within that contract. Agreement that parties have made that in the event that a dispute occur within this agreement, we're going to use an arbitration to resolve that matter. Then we have submission agreement, which is the second, which we will say that is an afterthought. So when the dispute has occurred, we didn't make any provision for any agreement. We didn't make provision for any arbitration or anything, agreement to go for any arbitration. But once the dispute has occurred, then the parties will sit down and say that we want to go for an arbitration. So when the parties say that we want to go for an arbitration, while they don't have any pre-existing agreement or prior agreement, then they will sign what we call submission agreement. Some of the institutions make room for that. If you look at a lot of arbitration institutions make room for that, and they accept such agreement that they will do submission agreements. Then the administration processes. What are the administration processes? The administration processes is also two. It's either you are going by an institutional arbitration or you are going by an ad hoc arbitration process. So the institutional arbitration is where the proceedings are administered by a designated arbitral institution. So when in the agreement or in the submission agreement, parties say that in the event of a dispute, we are going to use a settlement house to resolve this arbitration or to serve as the center, which will help us to administer the arbitration. Then it means that in any case, when anything happens, they will go through Shati ADR Center, Shati or Settlement House, or Settlement Arbitration rules. They will go under them and use it to resolve their matter. So arbitration institutions usually provide a set of rules which govern the procedure of the arbitration and manage the administrative side of the proceedings. So it's either the parties are allowed, most of the rules are flexible, which allows the parties to modify or change certain areas to suit the way they want the process to go. So the parties are not bound strictly to use it. Some of them are doing. So when you are choosing, you must also first read about that particular rules of the center, understand what the center requires from parties and what the parties can do, the do's and don'ts of the parties before you select that institution to do your arbitration for you. Then we come to the ad hoc arbitration. When we are talking about ad hoc, it means that there is no specific organization, there is no specific institution. So on the ad hoc, on the other hand, is a form of arbitration that is not managed by an arbitral institution. The fact that it is not managed by an arbitral institution does not mean an arbitral institution cannot be appointed to serve as a registry or anything. It can be appointed to serve as a registry, but it means that they are not using their rules. They are just serving, maybe they are keeping their documents there, or an officer from there is assisting them. So when it comes to ad hoc, it's a form of that is not managed by an arbitral institution. As a consequence, the parties are free to determine all aspects of the arbitration procedure themselves, including, for example, the manner and the appointment of the tribunal and the administrative process for conducting the arbitration. They can decide that they want to choose one person to serve as the registrar and where the person will help them to appoint the people and use it, or they can decide to choose an institution to do that for them. But this one, they don't make specific appointment of an institution that will do that. But when it comes to institutional, it means that the people making the agreement appoint a specific an institution to run the arbitration for them. Now we come to the process itself. The process, number one, is the case initiation stage. So when it comes to the stage initiation stage, what goes into it? So when it comes to stage initiation stage, a dispute has occurred. What should the party do? Party can only function based on the rules that the agreement made for. So first thing that we were saying that there must be what? An agreement. So you are satisfied that there is an agreement already. So when there is an agreement already, when it comes to initiation stage, what are you going to do? So you look at what the agreement provides for. Did the agreement provided for an institutional arbitration or an ad hoc arbitration? If the agreement provided for an institutional arbitration, then you go and look for that particular institution, the rules of that particular institution, and how you can initiate the process. So the rules of that institution will tell you that coming to us, for instance, when you go to the ICC, if you are going under ICC will say that submit a request for an arbitration. You have to submit a request, accompany the request with a fee, which is the last time I checked, it was $5,000, a fee. So the filing fee, you accompany it with the filing fee. So your request will be considered as having been filed when you file the request together with the fee. Then it means that you have completed with the filing process. An institution can also say that a different institution will have a rule which say that before you can initiate a process, you have to notify the other party of notice of arbitration. Other institution does not require that, but other institution may require that send the person a notice of arbitration. Then you copy the notice of you copy the organization, the notice of the arbitration. So depending on the institution. So before you can initiate any arbitration process, you must know whether it is going to be an institutional or an ad hoc. Then if it is an ad hoc, then you have to also look at, did the parties choose a rule, or they did not choose any rule? As I mentioned earlier, the uncitral rule allows for ad hoc processes. So if somebody wants to use an ad hoc and they choose the uncitral rule, so it means that if you choose the uncitral rule and you're going for ad hoc, the uncitral rule says that you must give the person notice of arbitration. There are organizations here in Ghana that will say that demand for arbitration, you must send a person a demand in the notice of the arbitration, you must demand for arbitration. Other institutions can say that you must request for an arbitration. So once it's an ad hoc, or if the parties also refuse to choose a rule on how to even initiate the process, then that is where preliminary meetings happens. Preliminary meetings happen because the arbitration agreements may not be clear as to how the process should be initiated. So the parties must have a preliminary meeting, which will be used to clarify, and the parties will further agree on the selection process or the initiation process, or how they want to go about the arbitration process. Then, or you can have conferences with them depending on the nature or the area you may find yourself. So that's why I put in the bracket preliminary meeting or conference, if any. So if any, then so these two, the first and second stage, will help you to satisfy yourself with any underlying issues that you may not understand. Then after that, you come to the arbitrator invitation stage or arbitrator appointment stage. So here, if the ICC rules that I use as first option, if the agreement, maybe the agreement in the contract says that each party will appoint one arbitrator and the other party also appoint one. So you, in submitting your request, you have appointed your arbitrator already. So the arbitrator, the organization, ICC also get in touch with the organization, the arbitrator, and invite the person that this is what has happened. You have been appointed. So now the parties have already appointed. The parties will definitely inform the arbitrator, but the organization also get informed and in touch with the arbitrator. Or in other circumstances, once there has been the process has initiated, there will be time that the parties will appoint arbitrators. So the appointment of arbitrator stage or appointment of the tribunal, whether 3, whether 1, or the parties will appoint the arbitrators. Having appointed the arbitrators, then the next step is the arbitration management conference. I'm using the Ghanaian Act as an example. Under the Ghanaian law, arbitration management conference is supposed to happen within 14 days of the appointment of the arbitrators. 14 days of the appointment of the arbitrators. So the 14 days of the appointment of the arbitrator must conduct what we call arbitration management conference. And the arbitration management conference must be done with 7 days prior notice to all the parties involved. So the arbitrator or the center that is managing the process must inform the parties 7 days to the arbitration management conference so that they can satisfy themselves with it. Let me also add that in the appointment process, as we all know, definitely qualification will come in. But when it comes to arbitration, because it's the party autonomy process, the qualification of an arbitrator is solely dependent on the qualification that is accepted by the parties. You can be a PhD holder or whoever, professor in arbitration or whatever in arbitration. Parties may say that we don't want you, and that is it. Whoever that the parties choose is the qualified person that the parties wishes to use for the arbitration. All right. So the next stage, which is the 5th, is the preliminary hearing and information exchange stage. So preliminary hearing stage. So after the arbitration management meeting, in some cases, after the arbitration management meeting, they will go straight to the hearing stage. In some jurisdiction, they may do pre-hearing and information exchange. But in most cases, pre-hearing and information exchange stage is done through the arbitration management conference so that they understand when they will do hearing, when they will do exchange of information, whether they should send it via email or how they will send those information and all that, and where meeting time, timetable, timelines and all that. Everything will be agreed during the arbitration management conference or at this stage, pre-hearing and exchange of information stage. At this stage, other information can also be agreed upon. Then the 7th stage, the 6th stage is the hearing stage. This is where the parties and the arbitrators will now sit and hear the case as it happens in courts. That when it comes to arbitration, we call the person who brought the issue a claimant, and the other party becomes a respondent. But if it is coming from the courts, if it's coming from a court, and if we have plaintiff, it will be plaintiff claimant, then so the title will not change. The plaintiff is the claimant, then the defendant becomes the respondent. So it's the same thing. So hearing stage, whereby here the parties will present their cases and adduce their evidences. If there is a need for them to do examination for discovery, that examination for discovery agreement will be agreed upon during the arbitration management conference, whereby the parties will agree that there will be examination for discovery, or we will not do examination for discovery, but what we are going to do is that we will do witness statements. So as it happens in court, whereby the people will just put their statement or witness their statement as a witness on paper and submit it to the court. That can also be done during arbitration, whereby the people can submit their witness statement into the arbitration. So it all depends on the agreement of the parties at the arbitration management conference or the pre-hearing and the information exchange stage. If the parties agree that, then during the hearing stage, all these things can be done. Then even, let me also add that during the arbitration management conference, the parties will also agree on the interim rulings or interlocutory things that the arbitrators can rule on it, and all that they can agree on all that during that arbitration management conference. Then the hearing stage will take the form of hearing each party presenting their evidence. After they have presented their evidence and everything, then the arbitrators will now go and examine the documents and every evidence that is presented to them and make what we call an award. That is the award stage. So the award stage, the form of the award will be determined during the arbitration management conference, whereby the parties will now tell the arbitrators whether they want them to give the award with an explanation, or they will give the award without an explanation. Please give me a second.
So we can as well begin to drop our questions on the
Okay, sorry, I had to take some more water.
box.
Yes, I'm back. Yes, so the award stage, as I mentioned, whether the parties will allow the arbitrators or the tribunal to give their ruling with a reason or without a reason. So it is all will be decided or determined by the pre-hearing conference, or what we call arbitration management conference. Then at this stage, the arbitrators will give their award. So after the award has been given, it depends on the jurisdiction by jurisdiction. In Ghana, for instance, when you give an award together with the arbitrators or the tribunal, have within 28 days to correct any typographical errors within 28 days. If you don't do it within the 28 days, you cannot correct any clerical error or typographical error within the award again after the 28 days. Then after the 28 days, you have 90 days to go to court if you want to set aside the award. Then after 90 days, you cannot set aside the award again. That is what happens here in Ghana. All right. So on this note, I would like to say a big thank you to you. And now I open the floor for questions. Thank you.
Thank you so very much, Mr. Isaac Asare, the founder, president of Africa Center for Collaborative Dispute Resolution, all the way from Ghana. I want to say thank you so very much. This was really beautiful and coherently and eloquently delivered. So we say thank you. We appreciate you. We say thank you, sir. All of us here, we say thank you. So please, the floor is open now for your question. You can also drop questions on the chat. So you raise your hand and ask question from this powerful lecture. Thank you so very much, sir.
Okay, Mr. Isaac, you can stop sharing. Mr. Isaac, you can stop sharing. All right, great. So let me implore everyone, if you can put on your camera, let's have a snapshot. We welcome comments. We welcome contributions. We welcome questions. Please, you can put on your camera. Let's have a snapshot. Let's have the privilege of seeing your beautiful faces. Thank you very much. We're not able to acknowledge the presence of some of our esteemed mentors, facilitators. We're not able to, but thank you very much. I earlier acknowledge the presence of His Excellency, Mr. John Agada, the former president of the Institute of Chartered Mediators and Conciliators. We are happy to have him join. We want to welcome you. Thank you very much, Ms. Pa, for joining all the way from, should I say Cameroon or Kenya or I don't know which one to use. So thank you. So please, if you can put on your camera, please do so that we can have a snapshot, please. If it's convenient for you. Kigali, Rwanda, thank you. Thank you. We appreciate you. We appreciate you. Please put on your camera. Let's see your beautiful faces and let's have a snapshot, please. If you can, put on your camera. Okay. Yes. Beautiful. Yes. Thank you for putting on your camera. Yes. Thank you. Thank you. Thank you. Please. Can I take the snapshot? Please. Okay. I think we can. Thank you very much for joining. We're happy to have you. Okay. Okay. Thank you very much. So please, this is the arbitration series. And then we have gone through, thank you very much, Isaac, for that wonderful work. He has given us history. He has given us the foundational facts we need to know. We say what we need to know. And so he has given us what we need to know in the course of the arbitration session. And so,
please, no.
If you are a novice, if you are a new person to the arbitration process, please feel free to ask questions. Then we have some arbitrators in the house. We also welcome you. Thank you very much for joining. So please, you can drop your questions if you have questions. If you have comment, please indicate with your virtual hand, and then we give you opportunity to ask your questions. Mr. Samuel is here.
Okay. Janet, okay. Nanchang says, thank you, sir, for this wonderful insight. Thank you, ma'am. And thank you for the knowledge field lecture. And David asks, please, how can I get the soft copy? Can I also get certified? Joseph, you can as well drop your contact. Let's reach out to you. If you can hear me, please drop your contacts. Let's reach out to you. You also say sorry that you can't put on your camera now, you're driving. It's okay, we understand. Okay.
Okay, thank you. Thank you very much. So
there are more questions.
Thank you very much. Thank you very much. So, Mr. Samuel, I don't know if you have comments, contribution. The chairman of the governing body is here. Also, please, if you have comments or contribution.
Good evening, Mr.
You are
Lecturer.
welcome to make.
Good evening, Mr.
Do we
Nachan.
have comment? I greet you. Can you hear me? Can you hear me?
Mr. Nachan, good evening.
Good evening, sir. Good evening.
Yeah. Good evening to our big mommy, the Governing Council Chairman.
Go ahead, we
Good
can
evening.
hear you.
Good evening to my Prof Isaac. Good evening to every participant. I want to especially thank the resource person for painstakingly taking us through the arbitration process in a very concise, beautiful manner. We deeply appreciate you. No comment from me, but just kudos to you. And special thanks to Shati, Settlement House ADR Training Institute, for doing all within their powers, going out of their way to make sure that the ADR space in Nigeria is sanitized. Thank you so much. I want to appeal to everyone that is on the call to do well to publicize the forthcoming training being put together by Shati. I'm sure the details will be dropped on the chat box. Thank you, thank you, thank you.
Thank you very much, sir. Thank you. Thank you. Okay, so I will assume that we understood the process, the processes in arbitration. You know, under the ADR, we have two major mechanisms that are being used: the arbitration and the mediation. So the mediation aspect has to do with the parties taking decisions for themselves, and then the arbitration aspect has to do with a third party, neutral, who takes decision on behalf of the parties. So this is the first arbitration series that we are having, and that's why we decided to have an overview of the process from the beginning to the end, so that you will have an idea what it is like. You know, perhaps maybe you have clients, if you are a lawyer who may want to engage in the process, at least you have an idea what it is. Very soon we'll start our certification program in arbitration. You know, before the middle of the year, or by the before the end of the year, we should start our arbitration certification training. In the meantime, we will continue to have our settlement hour, which is our continuous professional development program for parties, for members of the institute, for the ADR community, and for the world at large, to continue to have basic knowledge and understanding of what ADR is and how they can utilize the processes. So that is what we intend to do. We also have our training in mediation that is coming up between the 29th and of April to 3rd of May 2024. And if you are interested in the training, please, you can reach out to us. Some of the details have been sent on the WhatsApp, on the chat group. You know, you can reach out to us to partake. It's virtual, so you can partake in the training from any part of the world. It's actually an interesting training to do. We also have a discounted rate for the first few persons to register, which is 50% discount that is offered. So it's also stated on the chat box during the meeting. Please, if you are interested, or you know someone who would be interested, please do well too. I will also ask that, okay, the link to the settlement hour be shared be shared on the platform so that those who are interested can also join the group for information. They can join the group for further information on ADR, on trainings, on some opportunities that are coming up in ADR. Thank you very much. So aside from this, for those who are interested in the material and certificates for this program, for this webinar, you can drop your details on the chat box, just as it has been indicated. If you are interested in the certificate of attendance from this meeting, you can drop in and indicate your name, your phone number, your email address. We'll reach out to you. Attendance is free. In all our settlement, our attendance is free. So let me call on the chairman of the governing body of Settlement House ADR Training Institute for a comment or contribution before we round up. Your Excellency, ma. Your Excellency, ma, can you hear me?
Yes, I can hear you now. Sorry, I had network interruption. I will not be my network is being interrupted, so I didn't hear the last thing you said.
Okay, we are calling on you for maybe contributions, comments on the webinar, and then you eventually thank our speaker and close the meeting for us.
Okay, no questions. Have we taken all the questions?
Thus far, I think the participants properly understood the process, or some are conversant with it. There are no questions, so to say. And we've made some comments and introduced some of our upcoming programs, the training that is coming up very soon. And so we're handing over to you to appreciate the speaker, make your own contributions, and then we call it a day.
Hello? Can you hear me now?
Yes, we can hear you.
All right. I want to use this opportunity to thank our resource person, Mr. Asari. That is a very in-depth discussion. You have delved into the rudimentary aspect of arbitration. We so much appreciate all your efforts, your insights, your presentations, your submissions. And we believe that very soon you will be inviting us to Ghana to come and partner with you in your institute. Please, we are available at any time. And please remember that at any time we call upon you, don't hesitate to respond like you have done and you've always done. Thank you so much, participants, my learned seniors that are in the house. Thank you so much for joining. Thank you, Director. Thank you, former Chairman SN. We're honored to have you. We're honored to have your presence in this webinar. We will keep learning. Like I always say, no one has the predominance of knowledge. So we keep learning at any time there's an opportunity for us to learn new things. We come on board and then we invite you. On this note, because I know that the ADR people still have another meeting by 6 o'clock, I would like to close this meeting so that we can take a 30 minutes break before we join the other meeting. Thank you very much and do have a wonderful weekend. God bless you.
Thank you. Thank you. Thank you. Mr. Isaac, thank you very much. You've not told us anything about the center, and I say you should introduce yourself. You just
Okay, so let me say a big thank you to the chairman and the entire team, especially you, Nanchan. I think let me also thank Vikram. I think through Vikram, we got to meet on his program, and it has been good since that day. So thank you for the opportunity to be here. As Nanchan mentioned, it's called Africa Center for Collaborative Dispute Solution. We also train people in mediation, arbitration, and paralegal studies as well. We believe that not everyone can become a lawyer, but everyone has the opportunity to learn in some legal aspects because the laws are made for us. The laws are not made for only lawyers. And the parliamentarians that we send to Parliament or Senate House to make laws are not lawyers. We send them there to make the laws for us. So it is important that everyone learns an aspect of the law. And that's why we have a program called Mediation, Arbitration, and Paralegal training that we do for people. And also we do community activities like this Saturday coming, we are going to community, we call it Community Mediation Clinic, that we go there with volunteers. We give them the opportunity to also come. Those that we have trained, we go with them so that they can also learn the practice of ADR, how to receive cases. Then we also educate the people within those communities on mediation and how they can use mediation to resolve issues within the community in order to build harmonious environment within the community and also to help in achieving the SDG goal 16. That is what our focus has been. So as my mama mentioned that yes, when you call on us to partner, we will be happy to partner with everyone, anyone, any organization, and Shati is number one. We'll be happy to partner with you in doing programs together, in doing activities together. And also, we want to see cross-border practice when we have issues in Nigeria. We may not be able to come there. We can get somebody from Settlement House to do it for us. When you also have something in Ghana, you may get somebody from us to do it for you. So it's a win-win collaboration for all of us. And we are looking forward to also enter other African countries to review the acts, to see what is happening there, how is the practice there, and how can we all come together and also help in prioritizing ADR practice, because ADR practice, as we're talking about arbitration, mediation, and that thing, is not new to us as Africans. It is time for us to prioritize as people have called it, appropriate way of or appropriate dispute solution or African dispute solution, because this is what our forefathers used to do. They didn't know anything about courts, but we have now accepted the court system than even the one that is our own. But now I'm happy that we are beginning to go back to assess what we used to practice, although we may not know it as mediation or arbitration or whichever, but was it good for us that we can better the African continent? We can also make Africa to achieve the peace that we are looking for. So thank you all. I'm grateful for this opportunity, and thank you. AFCOT is ready to collaborate with you. Grateful to all of you.
All right, thank you very much. Thank you very much. So for the for those who may want to watch this again, you can go to our YouTube channel, Settlement House ADR Training Institute, and you will see the live recording of this there for you to go through. In the absence of any other thing, I want to appreciate all of you for creating time out of your busy schedule to be with us this evening. Please share the news. When you get the recording, share it with someone. Let somebody know that there are ways in which they can resolve this dispute amicably. And if you are interested in the training that is coming up very soon, please reach out to us. We can make it very, very convenient for you to partake in that training. Thank you very much and have a nice day. Thank you. Thank you. Thank you. Thank you, Gloria, for being there, for assisting me. Thank you. Mrs. Nanchan, thank you. Thank you, everyone. Have a wonderful day.
Thank you.